welcome this morning. We'd like to call the post-council session of March 19th, 2019 at 10 a.m. to order. We have two who will be excused today, both Dr. Bruce Bailey and Sheriff Nathan Curtis from Superior County. Nathan, sorry, Nathan. So I just slid in. I was looking at my notes. I apologize. For the record, Nathan is here. And also welcome to your first meeting. Great to see you here. We need an approval for the minutes of January 3rd, 2019. Have you had an opportunity to take a look at that? I will entertain a motion of approval. Motion of approval by Mike Haddon. Have a second. Second by Chief Chad Self. Call for the vote. Those in favor? Aye. Any opposed? We'll move forward. Annual quarterly reports from Lieutenant Jacqueline Moore.
So for the quarter of December 1st, 2018 to February 28th, 2019, we received 62 complaints. We opened 20 investigations. We did not conduct any administrative hearings. We closed 8 cases with no action. We received 6 voluntary relinquishments, and those are related to allegations of sodomy and sexual assault for one. Another was official misconduct lying under Garrity. Another was lewdness, sexual battery, and sexual conduct on duty. Another was child pornography. Another was sexual conduct on duty, and the last was rape and custodial misconduct. We reviewed 366 applications. 303 of those were for basic training, 34 were dispatcher, and 29 were for waiver reactivations. We currently have 70 open cases, 50 of those are active. Do you have any questions? Thanks.
We'll now hear from Linda Vitti. We'll move forward on disciplinary cases.
Good morning, members of the council. This morning we have a short calendar. The first case is Ariana Adrinola. Are you here? Ariana, would you like to come up?
Yes. Okay, thank you.
Ariana Adrinola is a dispatcher at VEC. The substantiated offense, can you hear me? Is this on?
Sounds like we got something. Okay. I'm not sure. Can you hear me?
Yeah, I can hear you. Okay. The substantiated offense is falsification of application to obtain certification, a Category C offense. Post recommends a 2-year suspension, and she waived. In fact, none of the cases today, there were no hearings on any of these cases. The guidelines, I call for a 2-year suspension. There are no aggravators, there are no mitigators, and no criminal case. On December 11th, 2018, Ariana Adrinola was investigated by Post for falsifying an application to obtain certification. Adrinola submitted an application to attend dispatcher training in 2014 and was subsequently certified. In 2018, she submitted a second application to attend the law enforcement officer training in Post. Investigators reviewed both applications and found several discrepancies between the 2 applications. Adrinola minimized the number of times she used marijuana and ecstasy on her dispatcher application. She failed to disclose she used multiple illicit and prescription drugs on her dispatcher application. She said her Leo application was truthful, but admitted she intentionally falsified her dispatcher application. On February 20th, 2019, she waived her right to a hearing before an administrative law judge and stipulated to the facts. Would you like to address the council? Is there anything you'd like to say?
Yes.
Okay.
Hi, I just first want to thank you guys for the opportunity to stand up here and explain myself in the situation that I find myself in. I'm here today because I lied. I lied 5 years ago on my application for UPD and my post application when I started as a dispatcher about my drug use in high school and early college. The reason why I'm here is because on my post application for the academy, I told the truth. I was 100% honest with my past drug use. And I told the truth because I felt overwhelmingly guilty for not being honest in the first place, and that I did not want to attempt to start another career on a lie. I had a copy of my first post application from the Post Dispatch and I could have lied again. I consciously chose not to do that. I wanted to do the right thing, be honest with myself and others, and move past my mistakes. When I first applied for Unified Police Department dispatch, I had returned home from California from an unhealthy marriage that ended in divorce. I have always wanted to be a police officer and thought that this job opportunity would be a foot in the door towards my ultimate goal. I was ashamed and embarrassed of not only the divorce that I was going through at the time, but also the decisions I'd made in my young adulthood. This job was an opportunity for me to start anew and move on with my life. Not having any law enforcement experience up to this point, I did not fully comprehend the importance of being honest on my application, on my post-application for dispatch. I not only lied by admitting the drugs that I had used, I also downplayed my use of marijuana and ecstasy. I did not divulge the truth due to fear that my peers would find out. I was worried that I would get into trouble and felt overwhelmingly shameful of the decisions that I had made. I wanted to appear normal and understandable, and the truth I felt was abnormal and excessive compared to everyone else. I did not want to make this information public. As a teenager, I started experimenting with drugs and hanging with the wrong crowd about the same time that my mother was charged with child abuse against me. And then she left to Idaho, abandoning me with my grandmother to care for me. I was going through a lot of psychological turmoil, abandonment issues, and frustration on the way that my life was going. I look back to the person I was 10 years ago, and I'm very thankful that throughout my life I've learned to cope with the issues in a healthy way. I'm not the same person I was 10 years ago, and I'm not the same person I was 5 years ago when I lied on my application. I've matured and learned from my mistakes and experiences and will continue to do so throughout the rest of my life. As of today, I am still a dispatcher for Granite School District Police Department, as well as for VEC dispatching for Unified Police Department. Throughout my career as a dispatcher, I've never had a write-up. I've never received a complaint. I've even received an award for my performance as a dispatcher in a high-priority situation, and up until I applied for the Post Academy, I'd never been asked to resign or been fired. That changed December 31st, 2018, when I was fired from UPD for lying on my application and also my post-application. That happened to be the last day that Unified Police Department had its own dispatching center before being absorbed by VEC, Valley Communications. I informed my supervisors after the post interview that I had, immediately after, and they've been very supportive of me ever since. VEC hired me as a full-time dispatcher due to the recommendation of my supervisors during the investigation. This act from my supervisors is an example of their support and trust of my job performance and character by those who have worked closely with me for the past few years. I fully accept that what I did was wrong and I deserve to be punished for what I did. I'm prepared to endure whatever suspension I am given. I'm ready to move past this in my life, complete my suspension, and have the opportunity to apply for the Post Academy again. I want to be the example to others that are in a similar situation. I hope to be relatable to others who are struggling with their own demons and be an example that change is possible. I've been put through the ringer this past year, and it has truly formed me into the person I am today. Again, I want to thank you all for the opportunity to speak. I appreciate your time, and I hope that it has encouraged understanding of the decision of my suspension.
Any questions for Ariana?
Did you self-disclose, or did this
Yes.
come out?
Yes, it was.
Did it come out during polygraph?
No, on my application for the Post Academy, I was honest, and then they compared the two, and I went in for an interview and let them know that I lied the first time, and this is the truth on the second one.
Do we have a motion?
Move to accept the recommendation.
We have a motion from Colonel Rappage to accept the recommendation for 2-year suspension. Do we have a second?
Second.
We have a second from Victoria McFarland. Any discussion? Those in
I think it may be a little bit, 2 years might be a little bit heavy for she's self-disclosed. I realize that there is a problem. I would make an alternative motion for a 1-year suspension.
We have a substitute motion from Spencer Austin for a 1-year suspension, and we have a second, let me call for, and a second from Dr. Frank Budd. Is there any discussion? Oh, sorry, those in favor?
We're voting on the motion.
We're voting on the substitute motion. Those in favor?
Aye.
Any opposed? Any further discussion? Seeing none. Thank you.
Thank you very much.
Next is Michael Anderson. Is Michael here, or do you have defense counsel? Yes.
Well, Michael Anderson and his counsel are present. Michael Anderson is a deputy with Cache County. The sustained charge was taking wildlife outside designated area and shooting from a public roadway, a Category E offense. He is still employed with Cache County. The Post guidelines call for a 6-month suspension, but Post is recommending a letter of caution. There are no aggravators. The mitigator is that there was no premeditation, and he tried to follow the law, and he self-reported. There was a criminal case. He paid a fine of $235. On September 30th, 2018, Michael Anderson was legally hunting pronghorn in Wyoming when he laid down approximately 10 feet off the road and shot a pronghorn. Anderson tried to verify the pronghorn was within his permitted hunting boundary prior to shooting the animal by looking at a map that depicted the differing hunting boundaries and reading the proclamation. Anderson was cited for taking wildlife outside the designated boundary and was warned for shooting from the road and paid a fine. During the Garrity interview with Post, Anderson did not deny shooting the pronghorn, but believed he'd been hunting in accordance with Wyoming law. He waived his right to a hearing and stipulated to the facts in the notice of agency action. Would you like to address? Thanks.
Morning, Council. J.C. Jensen on behalf of Michael Anderson, who is present. Mr. Anderson appreciates the investigation performed by Post, the facts as articulated by Post, as well as the recommendation made by Post, and he would ask that you accept the same. In the event any inquiries had or need be had, either he or I are happy to answer those. He also has a letter that's been drafted by his sheriff. I don't believe it's been disseminated to you. And upon consent of counsel, he would like to read that to you. It's only a few sentences long.
Please.
Thank you.
Dear Post Counsel, I am writing this letter of support for Deputy Mike Anderson and also support the recommendation of the letter of caution from the Post Counsel. Deputy Anderson notified his lieutenant of the citation when he returned from his hunting trip in Wyoming. He has been honest, upfront, and cooperated fully with our office's internal investigation concerning this citation. Our office has taken action internally with him and this incident. I want to thank Post for their investigator for their efforts and the timeliness of the investigation. Deputy Anderson understands all the actions that could be taken and has been willing to accept the decisions made concerning this case. I would just reiterate my support for him as well as recommendation for a letter of caution from the Post Counsel. Sheriff Chad Jensen.
Mr. Anderson, do you have anything else for Post Counsel?
I don't.
Thank you. Do we have any questions for Mr. Anderson? Motion from Chief Alan Swanson to accept Post's
The letter of counsel.
the letter of counsel. Do we have a second?
I'll second it.
I have a second from Lieutenant John Crowley. Those in favor?
Aye.
Any opposed? Seeing none. Call for the vote. All those in favor?
Aye.
Any opposed? Thank you.
The next case is Cristina de la Cruz. Officer Cruz, would you like to come up? Are you represented by an attorney? Okay. Cristina de la Cruz is an officer with the Department of Corrections. The sustained offense is a BCI violation, a Category E offense. The base guidelines is 6 months, but Post is recommending a letter of caution. The agency suspended her without pay for 16 hours. There are no aggravators, no mitigators, and the criminal case was declined. On July 13th, 2018, Cristina de la Cruz unlawfully accessed BCI-controlled records. The investigation determined de la Cruz accessed her boyfriend's BCI-controlled criminal history record after coworkers expressed their concerns that he might be a gang member. The investigation determined de la Cruz had violated department policy and received 16... This one says 16 days and this one says 16 hours. 16 hours. 16 hours off without pay. An outside agency was contacted to conduct a criminal investigation. The outside agency screened the charge with the county attorney's office. The county attorney's office declined to file the charge, and the outside agency closed their investigation. During the Garrity interview with Post, de la Cruz admitted she accessed her new boyfriend's criminal history record after coworkers brought concerns that he was involved with gangs. On February 19, 2019, Cristina de la Cruz waived her right to a hearing before an administrative law judge and stipulated to the facts. Would you like to address the council?
I just want to say that, excuse me, I know that I made a mistake, and had I known that it was wrong prior to doing it, I would have never done it. Throughout this investigation, I can feel proud to say that my integrity and honesty has remained intact. I wear this uniform with pride, and I hope to continue to do so. I realized that it was my fault for not educating myself more on the proper usages of UCGIS, and I can assure you all that this will not happen again.
Any questions for Ms. de la Cruz?
Recuse myself.
Show for the record, Executive Director Haddon is recusing himself. We also have a letter in your packet from Executive Director Haddon. If you would please take a moment and look at that. We have a motion to accept from Lieutenant John Crowley. Do we have a second? Sorry, I missed that. Sheriff Pulsifer. Any discussion? Seeing none, I'll call for the vote. Those in favor?
Aye.
Any opposed? Seeing none. Thank you. Next is Joseph Goodwin. Is Joseph here? You have counsel? Okay. Oh, okay. All right. So he does have counsel. However, he's been asked to wait until, unless he's needed, I assume. So we'll go ahead.
Officer Joseph Goodwin was an officer with West Valley City PD. The sustained offense was disorderly conduct, a Category F offense. The guidelines call for a 3-month suspension, and Post is recommending a letter of caution. He resigned from West Valley on September 27, 2018. He was placed on admin leave on May 30th, 2018. There are no aggravators, and the mitigator is that there's no evidence of criminal conduct. He entered a plea in abeyance to disorderly conduct to a Class C misdemeanor. On May 29, 2018, Joseph Goodwin was intoxicated and had a disagreement with his wife about holding their infant child. Goodwin left his home and went to a camper trailer that was parked on the side of his home and fell asleep. Goodwin's wife woke him up and told him to come inside the house. Goodwin's wife left the trailer, went back inside their home, and out of habit, locked the front door. Goodwin realized the front door was locked and used his foot or shoulder to open the front door. Goodwin realized he broke his front door, became frustrated, and went on a walk to calm down. Goodwin and his wife denied any physical or verbal violence between the two of them. On May 30th, 2018, the case was screened with the county attorney, and Goodwin was charged with commission of domestic violence in the presence of a child, intoxication, and criminal mischief. On September 4th, 2018, he entered a plea in abeyance to an amended charge of disorderly conduct, a Class C misdemeanor. He waived his right to a hearing before the ALJ and stipulated to the facts in the notice of agency action. Would you like to make a statement?
Hello, everyone. My name's Joe Goodwin. First of all, I just want to say I take full responsibility for my actions that night. It was an incident that does not represent myself or my character. I've been in law enforcement between the state of Utah and the Marine Corps for about 17 years. This behavior is something that I'm appalled by for myself, and something that will never happen again. I definitely learned that night and in subsequent days since then that I need to conduct myself in a far more appropriate manner than I did that night. I apologize to Post and to my department for any discredit that my actions caused upon them. As far as my resignation, I do want to explain that. I didn't resign out of fear of being fired by my department. I had an opportunity out of state to work with a friend in a small business and felt that opportunity might be very lucrative, and it was something that we'd been talking about for years. The opportunity was just right to do. With that being said, I didn't have any fear that I was going to be fired by my department. I did cooperate fully with them when I was there, as well as Post, and I want to say thank you to the investigator for his professionalness while conducting the investigation. Thank you very much.
Is law enforcement notified on this?
That night I was arrested. I requested the officer contact my supervisor. They contacted West Valley and spoke with now Assistant Chief Buchanan.
Okay. Who called?
I believe it was the patrol officer who arrested me. I actually do not know. Oh, okay. Yeah, I'm sorry, I misunderstood the question. Yes, the neighbor, my neighbor called.
All right, I missed that part. Any questions for Mr. Goodwin? Victoria?
I have a question, not for him, but is for the category F, is this a downward deviation from the baseline? Because isn't their baseline recommended a 3 month?
Yes, it is.
I just didn't catch if there was any mitigated.
Yeah, so the mitigator in this case was that there was no evidence of criminal conduct, despite the...
Okay, thank you. Any questions? Any further questions? Do we have a motion?
I'll make that motion to accept those recommendations. Letter of caution.
Sheriff Corey Pulsper made a motion to accept post guideline. Do we have a second? Second from Chief Alan Swanson. Any further discussion? Seeing none, I'll call for the vote. Those in favor?
Aye.
Aye. Any opposed? Thank you, Mr. Goodwin. Is Nathan Jacobson here? The record, Nathan is rising with his legal counsel.
Okay, Nathan Jacobson was an officer with Willard City Police Department. The sustained charge is electronic communication harassment, a Category D offense. Post recommends an 18-month suspension, and the baseline in the guidelines is 1 year. He resigned on February 7th, 2018. The aggravators in this case is that there are multiple offenses, and there are no mitigators. He pled guilty to 2 counts of electronic communications harassment to an amended Class C misdemeanor on July 30th, 2018. During September 2017 and October 2017, Jacobson used his department-issued laptop to obtain an unidentified an unidentified temporary telephone number. Jacobson used the telephone number or numbers to send more than 100 harassing text messages to his wife and her friend. A subsequent criminal investigation disclosed Jacobson used his department-issued laptop to create the telephone numbers, which he used to send the harassing messages. Investigators were able to link the IP addresses from Jacobson's laptop directly to the telephone numbers used to send the harassing messages. He pled guilty on July 30th, 2018 to 2 counts of electronic communication harassment as provided in Utah Code 769201, both of which were amended to Class C misdemeanors. During the Garrity interview with Post, he said he did not remember sending the harassing text messages, but after reading the text messages, he believed he must have sent them. Jacobson admitted he's used unidentified temporary telephone numbers in the past to prevent suspects from knowing it was him calling. On February 11th, 2019, he waived his right to a hearing before an ALJ and stipulated to the facts and the notice of agency action.
Mr. Jacobson or counsel?
Counsel, have any?
I don't see any. Go ahead.
First off, I'm ashamed of myself for even being here. I never thought I'd embarrass myself enough where I'd have to come to Post Council, so I apologize. I agree, I did this. I was going through a rough time, and I was starting to drink a lot, and that's how I was self-medicating, because I'd get home and I'd drink a fifth, and I made stupid choices. From this, I've been able to go to rehab, being sober now because of this, and that's positive for me, because it's been years and years since I haven't drank. And so I'm actually kind of grateful something happened where I had to finally go get help. I agree with what Post recommends, and I think it's good.
Any questions? Victoria?
And this is probably more for the investigator, were these messages all during times that would have been off duty at home?
I don't know. At that time, they just all came from the IP address from his computer, which was a take-home computer that he had access to.
But no information about whether throughout the day, only at night, type of thing?
You want to answer that, Mr. Jacobson?
I'd go home, I'd drink, and then that's when things would happen. So.
Okay. Any further questions? Counsel, do you have anything? All right. We'll go ahead and ask for a motion.
I make a motion that we accept Post Council's recommendation.
A motion from Chief Chad Soph to accept the recommendation of Post. Do we have a second?
Second.
A second from Spence Austin. Any discussion? Those in favor? Oh, sorry. Apologize.
Maybe Linda can help me with this. We're kind of on the bottom end of this category. Looking at some of the messages that were sending from an official computer, I'm a little rough with 18-month suspension. Why did we go that low?
That's within the guideline, and the baseline is a year. So we aggravated it from that guideline to 6 months for that second charge.
Colonel, any further questions?
I'd make an alternate motion that we move it up to the maximum of the category, which is 2.5 years.
So we have an alternate recommendation. Can you go ahead and give me, I missed what you said, sorry.
Move it to the maximum for category D, which is 2.5 years.
Request to move to the maximum of D category, which is 2.5 years suspension. Do we have a second? We have a second from Victoria McFarland. Do you have any further discussion? Seeing none, I'll call for the vote. Those in favor?
Aye.
Aye. Any opposed? Thank you. Motion passes.
Yeah.
Next is Cameron Page. Cameron, are you here? And do you have counsel?
It's a Utah.
See no one rising? Ms. Vitti?
Okay. Cameron Page is not employed. The sustained charge was driving under the influence of alcohol, a Category D offense. He did not appear in this investigation. This was a default. This case was resolved by default. The guidelines are for baseline is 1 year suspension. The range is 3 months to 2.5 years, and Post is recommending 18 months suspension. The aggravator in this case is that there's an active Utah state warrant. There's no mitigator. He pled not guilty and then failed to appear for his hearing, and a warrant was issued for his arrest, and it's outstanding currently. On May 20th, 2018, Cameron Page, a Post-certified dispatcher, was stopped for failing to stop before entering a roadway. During the traffic stop, Page was arrested for driving under the influence of alcohol. The investigating officer transported Page to the police department and asked Page to submit to a chemical breath test. Page's blood alcohol content measured 0.141. Page was transported to the county jail and booked for DUI. On August 28, 2018, Page entered a plea of not guilty to the DUI and failed to appear for the scheduled hearing. A warrant was issued for his arrest. He did not participate in the Post investigation and did not respond to the notice of agency action. An order of default was signed by the ALJ. Yes, sir.
We have a motion from John Crowley.
Maximum 2.5 years for his failure to show any responsibility.
We have a motion to take it to the maximum of 2.5 years. Do we have a second? I have a second from Mike Haddon. Any discussion?
I just have a question. What's Post's threshold for an aggravating factor? Is it based on a BAC level, or is it based on a combination of BAC and traffic pattern, or in general?
Yeah, BAC, it was double.
That's
which
typically
was
the aggravating.
0.16, but now could be 0.10.
Because of the change.
Because of the change, but that's something we're going to have to discuss. And
but in the
present
past,
to
it's
council.
been double.
In the past,
okay.
It's been double. Or if they are involved in an accident, it's also an aggravator.
Which is 0.05 now, so for those that are, just for the record.
Are you asking?
No, I was saying, so. We have a second. Is there any further discussion? That will go ahead and call for the vote. Those in favor?
Aye.
Any opposed? Seeing none, passes. Thank you.
The next case is Christopher Peace. Is Mr. Peace here? No one is responding. Is an attorney here for Mr. Peace? No response. Christopher Peace is not employed. The sustained offense was retail theft, a Class B misdemeanor, a Category D offense. Post is recommending 18 months suspension. The guidelines call for a baseline of 1 year, and the range is 3 months to 2.5 years. The aggravators in this case are that there are multiple offenses. There are no mitigators. He pled guilty in a criminal case, paid a fine, and was placed on 1 year probation. On January 27, 2018, Christopher Peace, an unemployed certified special functions officer, underrang multiple items with the intention of depriving the merchant of the retail value of the merchandise. A peace officer cited Peace for retail theft. On January 2019, during a Garrity interview with Post, Peace admitted that on 3 different occasions he entered a retail store, collected items he had no intention of paying full price for, took the collected items to the self-checkout, and then he would scan one item, put an item of greater value in the bag. He explained that on the first 2 occasions he did this with only one item, but on the third time the total was just under a $100 difference between what he paid and attempted to remove from the store. On March 5th, 2019, he waived his right to a hearing before an ALJ and stipulated to the facts. Did I explain that completely?
Any questions for Ms. Vitti?
You understand that, what he was doing? He is unemployed. He's an unemployed certified special functions officer.
And he admitted to doing this on 2 prior occasions?
Yes, he did
on the one you've related?
Yes, he did on a total of 3 occasions and admitted to that.
Do we have a motion?
motion that we move it to 2.5 years, the maximum for category D.
We have a motion from Spencer Austin to move it to the maximum 2.5 years for category D. We have a second. We have a second from Chief Alan Swanson. Any discussion? Seeing none, I'll call for the vote. Those in favor?
Aye.
Any opposed? Passes.
Okay, the last case is Shane Visser. Mr. Visser, are you here? Is there an attorney here for Mr. Visser? I see no response. Shane Visser is not employed. The sustained charge is DUI and intoxication, a category D offense. The guidelines baseline is 1 year suspension. The range is 3 months to 2.5 years, and post is recommending a 2-year suspension. The aggravators in this case are multiple incidents. There are no mitigators. He pled guilty to impaired driving on October 1st, 2018, paid a fine via bail forfeiture for intoxication on October 17th, 2018. On June 8th, 2018, Shane Visser was stopped by the police for a traffic violation. During the traffic stop, the investigating officer determined Visser was unsafe to operate a motor vehicle and arrested him for suspicion of driving under the influence of alcohol. The investigating officer transported Visser to the police station and asked Visser to submit to a chemical breath test. His blood alcohol content measured 0.140. He was given a citation for the DUI and released to a responsible party. On June 19th, 2018, Visser was contacted by the police. A county constable attempted to evict Visser from his residence, and Visser refused to comply with the county constable's court order. The constable contacted local police for assistance. When the officer arrived, he observed Visser to be extremely intoxicated. The officer asked Visser several times who he could contact for a ride from the location, but Visser would not cooperate. Visser exited the residence, went to his vehicle, and was arrested after starting his vehicle with a remote start. A charge of intoxication was filed on Visser with the county attorney's office. On October 1st, 2018, Visser pled guilty to 1 count of impaired driving under Utah Code 416A 502.5, a Class B misdemeanor. On October 17th, 2018, Visser's bail money was surrendered in lieu of paying a fine after he was arrested for a warrant that was issued because he failed to appear on the original intoxication charge. He failed to respond to the notice of agency action, and an order of default was entered.
Any questions for Ms. Vitti?
Yeah.
Colonel Rappage, what was the question?
Clarifying, 2 charges here.
Yes, 2 separate charges. Seeing no questions, I'll call for the vote. And call for a motion, sorry. Go ahead. A motion. I'll call for a motion.
I would motion that we bump it up to the max, just because there's 2 separate incidents.
So I have a motion from Chief Alan Swanson to move it to the maximum of the category, which would be 2.5 years. Do I have a second? I have a second from Sheriff Pulsifer. Any discussion? Seeing none. Those in favor? Aye. Any opposed? Passes.
That's it. Thank you.